morning, everyone. We're so pleased that you could be here for this panel and this conference. As Kirti said, I'm Holly Fechter. I'm with Covington and Burling, and I'm really excited to hear from our panelists today. We're going to have a conversation, and then at some point I'm going to invite you to ask your questions, so please be thinking of them, and we'll have time at the end for everybody to participate. Well, first I want to start from a U.S. perspective, thinking about the patent system, and then we'll broaden out to the rest of the world. And let's start with Patrick, because the Chamber every year comes out with a report to talk about the state of the U.S. patent system. And I think those of us who've been following it for a while saw that the U.S. did well, and then it dropped significantly. But now the Chamber is saying we're back up there again. But I think the story's probably a little more complicated than that. So Patrick, could you tell us more about the Chamber's report this year?
Sure. Thanks, Holly, and thanks to all the organizers for putting together a really tremendous event. Really honored to be associated with it and with these distinguished panelists. If you've heard of the work of GIPC, it may well be through the U.S. Chamber International IP Index that we've published now for 7 editions. We are the dedicated voice of the U.S. Chamber of Commerce and some 3 million members we represent on issues of intellectual property-led innovation and creativity. One of the contributions that we try to make that we hope is useful is we do some targeted research. And one of our signature research platforms is this International IP Index. I'm not going to go into great detail now, but I'm happy to get into it more in conversation with you and the other speakers. But I'll just give a quick overview for those who may not be as familiar with it. Again, we have done this now for 7 editions. First edition, we looked at 11 economies on 25 indicators. And for this year's 7th edition, we're up to 50 economies, accounting for about 90% of global GDP. And we measure them against 45 indicators in 8 categories. So it includes, the basics, patents, copyrights, trademarks, trade secrets, but also enforcement of those rights, systemic efficiency, licensing and commercialization practices, as well as participation in some of the cutting-edge, standard-setting international treaties and trade agreements that are helping to define what an IP system looks like in the 21st century. And as you look at this, this is the ranking chart for the latest index that came out on February 7th. When you look at it, I don't really like to dwell too much on where is China vis-a-vis India, where's, U.S. vis-a-vis Japan. Sure, that's important. We can get into that. What strikes me looking at this chart is that 25 years after the negotiation of the WTO TRIPS agreement, no 2 countries score alike. And in fact, if you were to look more closely at the individual scores, you'd find that even where they're very close together, there are wide variations in terms of how they're protecting trade secrets or copyrights or patents, or how they've structured their system to enable entrepreneurs to take advantage of the IP system. So 25 years after the TRIPS agreement, we have countries across the board making independent, sovereign decisions about how they protect intellectual property, both in their economy and for all the trading partners that they do business with who want to bring innovation and technology or innovation and creativity to their markets. Why does that matter? Well, some of the research associated with the index, and I encourage you to look at the statistical annex on our website, theglobalipcenter.com. What we've done now over several editions of the index is to correlate statistically the findings about the strength of a country's IP system to a whole host of socioeconomic indicators, including job creation and knowledge-intensive industries, innovative or creative output, access to innovation and creativity. And across the board, we found that as countries invested in a stronger IP system, they saw more of these benefits that every single government wants for their citizens. And that is a big part of the message that we're sending around the world, as well as here in the United States, is that an investment in the IP system is an investment in domestic welfare. It's an investment in access to technology, and it's an investment in the ability to create technology at home. I think one of the failings that we in the IP community have had is that we talk to people about IP sometimes in the wrong way. How many of us have talked about a patent as a reward? I'll certainly put my hand up. I think we should all take a pledge to eliminate reward from our intellectual property vocabulary. Why? Because it suggests something that comes after, something that's discretionary. So if you're thinking of innovation as an equation, in this formula you have innovation, you add an intellectual property right, and that equals a reward to the inventor, or in the copyright, a reward to the creator, but a cost to society. Who's paying that reward? The way we look at intellectual property, and I imagine the way most of you do too, is that it comes first. It's a precursor. So in that equation, you have an IP system that's strong, that's reliable, enforceable rights, that is a reliable vehicle to hold value in an intangible asset, and that results in the ability to invest. So IP plus investment equals innovative output. That's the message we're delivering in countries around the world. I think increasingly a lot of the developing countries we work with are getting that. And so while we continue to see sort of those high-level political debates about compulsory licenses and TRIPS flexibilities, you see more and more markets, India, Indonesia, I would even put South Africa in this category, investing in IP education in their schools, IP awareness raising among entrepreneurs, facilitating registration of rights, and even trying to figure out how entrepreneurs can utilize their IP as an economic asset, as collateral to access financing. This is exactly where the world needs to be going, frankly. It is not quite there yet. But at the same time, we've seen this questioning in the United States of, well, are we really as committed to intellectual property as we have been? And that takes me to the second of two slides. This is just sort of my crude illustration of the evolution that takes place within the intangible economy with intellectual property rights at the center of it. And when you have a strong intellectual property system that is that reliable store of value, then you see companies like those in the 5G space investing at a very early stage in innovative capacity, in the R&D personnel that are necessary to drive innovation, in the investment in business processes and so on that allows them to be innovative. That, in turn, allows product development and commercialization, which in a really well-functioning market then goes to the ability to enforce and protect rights and ultimately to trade effectively in them. We talked, the last panel talked a lot about the importance of licensing. And to me, a market that works is one that allows liquidity, that allows financing of assets and free exchange of assets. We're not there yet on IP rights. We're certainly not there on the broader class of intangible assets that are coming to dominate the 21st century economy. You think of relationships, data, software, business processes, workforce talent, all the things that today make up an ever more dominant share of market value among our businesses. We have not yet learned how to define, account for, protect, enforce, and especially to trade in those. There's a initiative underway by the Licensing Executive Society to create standards for IP licensing. I think this is one of the most important things in our space that we should all get behind and encourage. Because if we can't figure this out, then we are in no position to take advantage of all the intangible assets in our economy. To me, this is the frontier. The U.S., on the U.S. Chamber ranking, #1 in the world in IP protection, with a steep drop-off after that. And yet we have not positioned ourselves to take advantage of intangibles. If we haven't done it, you can bet that nobody else has. That's the race that we're in, is to create an effective market for intangible assets that allows these leading companies to collateralize their assets to access financing in a much more fluid way that injects liquidity back into that system for early stage investment in intellectual capital creation. So that's where we're headed at GIPC, and look forward to the conversation, Holly.
Thank you, Patrick.
Thanks.
Let me try to pin you down, though. The U.S. did move up some. What were the particular factors in the study that led to that change?
Sure. So basically, two things. The patent category of the Intellectual Property Index contains 8 indicators, so any country can get a score ranging from 0 to 8. The first indicator is, do you provide a 20-year patent term? And every country measured in our index, except Venezuela, did. The rest of the indicators really go to, what are countries doing after that to chip away at that 20-year patent term? So are they providing an effective patent term of protection? Two of those very important indicators are on patent eligibility, where the U.S. scores 0.5 point out of 1, and the second one is patent opposition, where the U.S. scored 0.5 point in the 6th edition of the index. It scores 0.75 point out of 1, and which was enough to bump it from, a tie for 12th in the 6th edition to a tie for 2nd in the 7th edition. That is entirely on the weight of the steps that Director Iancu has taken at the USPTO to inject some further transparency, predictability into that patent opposition system. Now, if those advances are not then secured appropriately, in our public policy, then that could be a fleeting advance.
Yeah. Well, Adam, let's turn to another subject. You've been in D.C. for a while, so I think you can probably appreciate that this town is about as partisan as it can get. I think we're all sad to say that is the case. But there is one area that the president and many Democrats agree on, and that's regulating the price of drugs. And we've seen many different pieces of legislation introduced. Some involve compulsory licensing. So I think there's going to be discussion on Capitol Hill and elsewhere about that issue. But it's not just Congress. We've seen all around the world that we've got many instances where markets are not setting the prices of IP, but courts, regulatory bodies are. Tell us more about that, what you see.
Okay, thank you. And for those who know, I am standing in, although there is certainly no substitute for the inimitable Professor Richard Epstein, but I was happy to speak given his inability to come today. And Holly, you mentioned, yes, there's been a big push currently with respect to legislation for imposing various sorts of de facto and express price controls on pharmaceuticals. But there's a broader concern about this more generally, and you mentioned how that this is occurring around the world, but it really is occurring even across industries. People are very not aware of how much price controls exist within both the creative industries and the innovation industries. And in fact, recently when Congress passed the Music Modernization Act last year, something that a lot of my friends discovered and were emailing me about and were asking me about on the internet is that one of the things that the Music Modernization Act did was it updated the rates that were set by a rate regulation board for the compulsory licenses for songs. And they were shocked by this. They said, really? There's a rate regulation board that sets prices for the transfer of songs in the marketplace? I said, yes, this is not set by the free market. Songwriters don't have the freedom to do this. And this isn't unique just to songwriters and to music owners. Senator Tillis mentioned, kept mentioning Queen's Bohemian Rhapsody from the 1970s. Many people don't realize that the satellite and cable industry function under compulsory licensing schemes set in the 1970s. So long before the personal computer revolution, long before the internet came about, long before streaming came about with high bandwidth access to the the internet, right? These industries and these creators, even in the creative industries, are functioning under various compulsory licensing schemes and rate regulations that are imposed upon them by government agencies and boards from decades ago. And in fact, many aren't aware of the fact that ASCAP and BMI, which license songwriters and music for playing in various public performances, such as bars and other places. When you hear songs playing at a restaurant and things of this sort, they got the license from that. They're functioning under a rate regulation set through an antitrust consent decree that's over 70 years old, from the 1940s. So that makes that really puts the context for the constant references to Queen's Bohemian Rhapsody the framing, but. And so this isn't just through legislation either, it's also through the courts. So many in the innovation industries have been complaining, and rightfully so, for at least 10 years now about their inability to obtain injunctions through as a result of the Supreme Court's eBay decision in 2006, forcing them into judicial set reasonable royalties, which is a court-based compulsory licensing scheme. And then, of course, you have through agencies. So this is across the entire government, the agencies, and in particular, you have de facto rate regulation, de facto price controls through antitrust. I mentioned the consent decree, the antitrust consent decree under which ASCAP and BMI have been functioning. And this is really what happens with antitrust actions, which dictate the terms and conditions under which commercial entities and innovators can go out into the marketplace and enter into transactions and create the types of innovation markets that follow from the production and creation of new patented technologies and new processes and other types of innovative discoveries that are foundational to driving our entire innovation economy. And so you have widespread interference in the marketplace right now through legislation, proposed new legislation in pharmaceuticals, and the pharmaceuticals is a real concern. You know, the average R&D expenditures behind every successful pharmaceutical product that makes it to market is approximately $2.6 billion. And that has to be recouped. That's ex-ante investments that have to be recouped before, as they continue to reinvest in new innovations and to continue to develop the new also commercial innovations to deploy these products in the marketplace, because a significant amount of innovation occurs after the initial discovery in terms of how to deploy the molecule into the body through either pills or through other types of deployment mechanisms and things of that sort. And so when you have government agencies and government regulators, whether they're judges, whether they're heads of agencies or bureaucrats or legislatures who are beholden to claims upon them and interests that don't relate to and don't derive from the value of the products that have been created, then you're creating problems in terms of people's ability to not only recoup the massive investments, the R&D expenditures that they've made to create the innovation in the first place, but even more importantly, their ability to go out into the marketplace, because that's the whole function of intellectual property. That's why we have an intellectual property system, so that creators and innovators can do exactly what farmers and bike manufacturers and car manufacturers can do, which is go out into the marketplace and license and transact with other commercial actors, create the value chains necessary to not just to build, but to distribute new innovative products and get them into the hands of consumers at the low prices that we're seeing. For instance, our incredible smartphones that we have today.
Thanks so much. We, I think, all benefited from the earlier panel in learning more about 5G and appreciated that. If people are familiar, the Committee on Foreign Investment in the United States figured this out quite a while ago, and last year did issue an order making it clear that it was critical to the national security of the United States that a U.S. company lead in 5G foundational technology. In addition to that, we have an initiative by President Trump on emerging and critical technologies that covers 5G, AI, the Internet of Things. So clearly there is a deep interest by players in the U.S. government in these critical technology areas, but we seem to have a contrast because at the same time, policymakers are expressing so much deep interest in those technologies and the U.S. being able to control those technologies. We've got the courts with their Section 101 jurisprudence and very much weakening the idea that one can patent software in these areas. Jonathan, I'd love to hear more from you about that issue and where you think Section 101 is going to go from here.
Sure, thank you, and thanks for the opportunity to speak to everyone here today. I think the patent system right now is at an unusual juncture point. If you take the eBay decision back in '06 as a benchmark, if you take Supreme Court decisions since that time, roughly 3/4 result in substantive outcomes that make patents worth less than they were prior to that decision. Those decisions tend to be unanimous or close to unanimous, so no anticipation that that trajectory would change. So what's different? What's different is Director Iancu at the PTO and Assistant Attorney General Del Rahim at Antitrust DOJ. They have started telling a different story about the patent system, a story that has a long tradition in patent case law, in the patent statute, and a story that has a strong empirical basis. It's a story about the deep connection between secure property rights and risk capital. That's the magic that makes Silicon Valley happen. That's the magic that made biotech happen down in San Diego, that made Qualcomm happen. And doctrines such as Alice and Mayo that raise barriers to patentability that hadn't existed before, that use 101 to address issues that could have been and historically had been more surgically addressed through non-obviousness and other doctrines. And I really would like to, even though you didn't ask me, I would like to underline the importance of the eBay decision. This is the fundamental mistake. You cannot have a functioning property rights system without the credible threat of an injunction. Without the credible threat of an injunction, and I'm going to follow Patrick's lead here, and I'm not going to talk about the reward. If you don't have the credible threat of an injunction, you can't have markets because you can't have negotiations. The fundamental value of a secure property rights system, it's not so much of the reward, it's that you allow the market to price out the asset. If you allow the market to price out the asset, then you get the resource allocation efficiencies that you can't get under state-sponsored capitalism. And so I think what will happen in 101 is important. I think you've seen things being done through the patent examination guidelines just in the last 12 months through the what's become to be known as the Berkheimer memo, addressing Alice Step 2, the memo on memo to examiners on method of treatment claims, which addresses Alice Step 1. A really interesting pushback from the USPTO on applying Mayo and Alice through the venue of examination. But I really think the fundamental point is to restore the injunction backstop. That's really the bread and butter of any robust IP or property rights system more generally.
And Jonathan, just to follow up on that, we do see that other countries, other jurisdictions around the world are more willing to use the injunction as a remedy. What is it going to mean for the U.S. to see this divergence? What do you think that's going to mean?
Yeah, we have seen some isolated court decisions in some jurisdictions. My personal view is I'm still not convinced when we see commercially significant jurisdictions outside the U.S. Using the tools of antitrust. I don't call it antitrust. I would call it nominal antitrust to reset the value of patent rights for the benefit of local device manufacturers. the commercial values, the billions of dollars that were reset through the antitrust actions in People's Republic of China, in Korea, in Taiwan. I think those still dwarf in importance the isolated court decisions where injunctions have been issued. And where we do see the divergence is we see it domestically. We see it in the reset on SEP-FRAN policy by Assistant Attorney General Del Rahim. We know that the PTO and DOJ antitrust will be revisiting the 2013 report. They have specifically talked about that they believe that prior DOJ antitrust, the prior report, they've specifically called out courts who have interpreted FRAN to mean that it amounts to a quasi-forfeiture of an injunction, which is not consistent for the overwhelming history of the SEP markets. There was not a universal consensus that FRAN meant no injunction. That is a recent regulatory innovation. It's an innovation that has been advocated for by the downstream implementers. And so that's where I see the divergence, again, going back to my original point, the new story, which is really a rediscovery just of the basic economics. It's grounded in theory, it's grounded in empirics, it's grounded in the history of the patent system, the innovation system, that the injunction is important. I would hope that other jurisdictions would build upon what some isolated courts are doing, but I think it has to happen through their competition authorities in doing competition law so that it protects competition, not that it protects certain competitors.
Well, it was so refreshing to hear from Senator Tillis this morning, and what an amazing opportunity for people who are focused on intellectual property that the Senate has created this new subcommittee. So I think there'll be much more focus in the Senate on these issues. Senator Tillis acknowledged that we do need a solution to the Section 101 jurisprudence. I think very colorfully calling it a cluster. So anybody on the panel, if you were to advise Senator Tillis and Senator Coons on how to fix Section 101, what would you tell them? This is stumping the panel.
I'd return to my early, I think the historical treatment of 101, if you go, I'll give a law school example. So patent law courses used to not spend a lot of time on 101. And that's because it wasn't historically much of a barrier to patentability, because all of the work of filtering out non-obvious, obvious or non-novel inventions were done through those doctrines. And they can be applied far more surgically than a broad brush, expansive interpretation of these judicial exclusions.
Yeah, I might just add one other thing on 101, which is that when the Supreme Court decided Alice and Prometheus and the like, they didn't know it, but they embarked on a massive experiment in industrial policy. I think Adam has written on this in his article, Turning Gold to Lead, and I think Dave has also written on this. And they did it at a moment in time where China was doing precisely the opposite. So China was doing a conscious industrial policy, and the U.S. was doing an unconscious industrial policy. In fact, when I read those decisions, I regretted that we didn't have a 5-year economic plan, because that could have guided the Supreme Court of the United States in thinking about how to balance where the country should head. I'm being quite candid. Whereas the Supreme Court of China and the Chinese Patent Office knew they had to develop the software industries. They had to develop their fintech sector. They had to develop their healthcare sector. And because of that, they had the information which our Supreme Court lacks on where the country wants to go in developing its industries, its competitiveness, and how it stands. So, but for, and in this very minor sense, I kind of regret what Director Iancu is doing, but for the fact that we're pulling back, which is the wise thing to do, we would have this great experiment between two countries right now about whether weakening IP rights in that sector, strengthening it in China, two countries locked head-to-head in certain competitive areas, whether that is going to drive capital, talent, R&D, high-quality patents away from the U.S. and into China. Are the patents really going to work that much in that direction? Now, hopefully, we're going to pull it back a little bit, but I think actually already some of the early data suggests that it was having an effect. That is, that perhaps plus the trade war, R&D spending intensity is up in China, patent filings in those areas is up, certainly capital formation around some of the new fintech and other companies in China has been going up. All that suggests that perhaps it was having its intended effect.
Yeah, so it's hard to be the philosopher king and want to say this is how how 101 should be written and should be applied. But Jonathan and Mark, I think, made some really good points, and I'll just add a little color to that, which is that it's always been a key feature of the U.S. patent system, and what has been a distinctive feature of it in comparison to other countries' approaches, that we've been very open and receptive to the next new technological wave, the next new step in innovation. So, for instance, when we broke from England and we adopted our own patent system, we protected process patents. England did not do that. And that was significant. In fact, the very first patent that was issued in this country was a process patent for a method for making potash. And I often have pointed out in some of my writings and public comments that if you applied the current Supreme Court's approach to what counts as a patent-eligible invention, that very first patent would be deemed to be ineligible because it was just a method of increasing and decreasing the temperature in the process of making potash. And so there's something fundamentally wrong when a patent that was signed, reviewed by Thomas Jefferson, himself somewhat of a skeptic about patents, and signed by George Washington, the people who were involved in the framing of this country and the creation of the foundations of our patent system, when they themselves approved a patent that would now not meet the test that's created by the Supreme Court. I'm sorry, calling it a test is too nice. The inquiry that they've created through their 4 cases, Bilski, Mayo, Myriad, and Alice, which in more darker moments I sometimes refer to as the 4 horsemen, that it's you have a real serious problem. We protected business methods. Research has shown that a significant number of patents that issued in the 19th century were business method patents. These are not a new phenomenon in this country. We protected early aspects of software code. I always like to say that the very first software patent that was upheld by the U.S. Supreme Court was in 1853, when the Supreme Court affirmed Claim 5 of Samuel Morse's patent on the electromagnetic telegraph, because he didn't just patent the telegraph, he patented what we now call Morse code. And what is Morse code? It's a binary transmission language that that functions on an electromagnetic system for communicating information. In other words, it's software. And in fact, we now know Morse through Morse code, not through his telegraph, even though he really invented the telegraph. The code was simply what operated on it. And the Supreme Court said, this is clearly patentable. So, and yet, what is now closed to innovators in this country? It's the software innovators. It's the people who are creating and investing the billions of dollars to come up with the code, whether it's our digital telecommunications technology and 4G, whether it's enterprise systems, whether it's IoT, whether it's AI, whether it's fintech, and other things. And in fact, you can't even divorce the high-tech industry and the software developers anymore from biopharma, because there is what I've heard referred to as the great convergence, because a lot of the diagnostic patents are actually patents on the algorithm, on a software algorithm that's used in a diagnostic machine or in a method of treatment. So you can't say, well, the software is unpatentable, but these types of incredibly important, life-saving, life-changing discoveries by the biopharmaceutical industry are, because they go hand in hand now. This is what biotech means as we use that phrase. And yet, this is exactly what is being closed by our patent system now, which is this change that in this article that I wrote with Kevin Madigan and we published a couple years ago. We called it Turning Gold to Lead, because the U.S. patent system used to be referred to as the gold standard system in comparison to other countries, in the sense of our embrace and promotion of new innovation, the new types of technological discovery discoveries and processes and methods and products that then led to new innovation markets, as economists have shown repeatedly, and as Jonathan just described. Property rights serve the foundation to produce and create new markets, new market activities, to get products and services into the hands of consumers. It's not about rewarding inventors. It's about creating those markets and those market mechanisms that make everyone's lives better off and grow innovation economies. And this is the concern today. I would just say, return back to the original understanding, whereas if your claim is just an abstract idea, if it's just a purely abstract idea, E equals MC squared. If it's a pure law of nature, E equals MC squared. If it's if you're just claiming a rock in the that exists in the world, that's not patentable. But insofar as it's a human-made activity, or it's something that derives from human activities like isolation in the lab, that's no longer a natural thing. That's no longer an abstract thing. That is exactly the type of innovation that we're promoting. That undergirds our entire innovation economy.
And Holly, on 101, I think I'd simply like to associate myself with Chairman Tillis's comment that no industry sector should be per se patent ineligible.
Fantastic. Well, let's turn our attention more broadly, Mark. We, as everyone knows, are in a trade war with China. And intellectual property issues are a key part of the conversation. But we also know that China has done a tremendous amount to update their intellectual property system. And it would be very helpful, I think, if you would unpack what you've been seeing, what's happening in China, and how do you think that compares with what we're doing here in the U.S.?
Right. So I just mentioned the patentability issues, which were done by revisions to China's patent examination guidelines about the same time as the Four Horsemen. So that's one thing. The other thing also to keep in mind is China has a fairly automatic grant of injunctive relief. There's no eBay doctrine. The injunction rate is between 90 to 95%. The reason there's a missing 5% is that some people don't want injunctions. So actually most of the reasons that injunctions are not granted is some folks just want money, even in a low damage environment like China. So it's an interesting moment in time because China's also a major center of manufacturing, in case you're not living in this century. And as such, it's a chokehold. So you can go to China and get an injunction and stop the manufacturing of products that may be delivered all over the world. That's a significant strategic advantage, even if you view the system as not giving you adequate damages. And we've seen just recently in Qualcomm's cases, Germany, the US at the ITC, and Fuzhou, I believe, in China, where two courts granted injunctions and an ALJ sitting here in Washington, D.C., declined to do that. So it's really quite striking around the same set of patents. That's just historical, but the other thing, I think one of the most dramatic things that has been ignored by the media and others in looking at China's development over the past few years is in 2014, IP cases, along with 30 million other cases, came online. And for folks who have been pining away to be able to do research on China's legal environment, this is a gold mine for lawyers and for social scientists and others. So we now have roughly 500,000 IP cases online. We, in the most litigious society in the world, last year China had 280,000 IP cases, up 40% from the prior year, which itself was up 30% from the year before that. You're no longer shooting in the dark, even though 70% of the cases are, only 70% are published. We can always wonder what is in that missing 30%, a very legitimate concern. But we have data here that can guide us and give us some good insights. Stepping forward to the moment in this trade war, I think the dramatic turnaround, if you will, in this administration is this engagement on technology and on licensing. I fought for 15 plus years for China to change its discriminatory treatment of foreign licensors licensing into China under something called the Administration of Technology Import-Export Regulations, or what I call the TIER. And I'm always flattered when I see the media now calling it the TIER. That was my creation. It should be a TIER, but I dropped the A. And those regulations mandated that Chinese licensees got ownership of all improvements. They were indemnified against third-party risks, et cetera. And just about 10 days or so ago, buried in a bunch of other legislative changes with no explanation, that those most offensive provisions were revoked. Pretty significant. China remains a largely under-licensed environment. It's about equal to the market in Taiwan. Yet China has about 30% of the world's high-tech production, and about 3% of U.S. technology purchases. So there's a big shortfall in infringement or under-licensing. The forced technology transfer narrative, which is obviously kind of the tip of the spear in our trade war with China, a little bit hard to document, although there certainly are a lot of obscenities around what has happened to some companies. And China also changed its foreign investment law to say that there would be no compulsion to transfer technology as a condition for an investment approval. We'll see how that works out, because as in many things, when you have an economy that's largely state-controlled, there are many ways to put pressure on foreign investors other than the de jure, it's in the law. You want to be able to sell to the government hospital. Well, you're going to have indigenously innovated products. You're going to have to transfer your technology locally, et cetera, government procurement and other mechanisms. So that was a significant change in itself. The other major development, and actually I worked with the U.S. Chamber in sending a letter to the Supreme People's Court on this, was the precise time, again, when our federal circuit is under attack, China decides it needs a federal circuit type court as well. So it's kind of, these are maybe three horsemen of similarity, if you will, patent eligibility and among them. Now we have the federal circuit issue. Basically for the same reasons as the federal circuit in the U.S. They need to ensure that decisions are similar for the same issues in different jurisdictions. Even though China is not a federal system, they should all be following the same dance tune, but frequently courts do not. And they put in a good group of judges into that court, which is kind of an appendage on the Supreme People's Court. Interestingly, of 9 Supreme People's Court justices, 2 of them now are IP justices. I mean, if you want to judge sincerity of a country, you can see who gets promoted in a particular issue, and having 2 justices up there. And I've seen a lot of other people with IP backgrounds get promoted to very high levels in the Chinese government. I left the U.S. government. I have something to say about IP, but I wasn't getting promoted that quickly like they were. But anyway, I'm not coming back. It's not a pitch. Still, the fact remains, all these things look nice on paper. And we hope they work out well. And there are talented people, I think, who believe in IP, who are working on these issues. But you still have the heavy hand of the state. And I think this goes back to the earlier comments, how China is different from Japan and other places. I mean, you have a state, I mean, if you look at the TRIPS agreement, what was the U.S. afraid of with ex or communist or transition economies? They were afraid they would not buy into an IP system. And there's basically 2 provisions, a transition provision at the end of the TRIPS agreement, and there's a provision put in at the beginning of the TRIPS agreement by the Hong Kong delegation that IP is a private property right. No one thought that a country would buy into it so much it would become a competitive threat, and that they would put their fingers on the scale so that it would be hard to have adequate civil remedies, to collect damages, that antitrust would be abused for industrial purposes, that you have industrial targets like having 3.3 patents per 10,000 people. The old target, which by the way is the state of Ohio if you were looking for an analog, and now China's up to about 11 patents per 10,000 people. And industrial and other targets like standardization targets, participation in global standards, becoming a center for global litigation, et cetera, at a very granular level and at a macro level. This is unexpected. And because of that, we're seeing China as a competitive threat. We're also seeing a lot of smoke around the system. So people are afraid about, China and AI, China and 5G. And it's increasingly hard to tease apart what is really meaningful in a system that has a patent office that's about 5 to 6 times larger than the U.S., where 2/3 of the patents are not examined, as just one of many examples. You have to start looking at forward citation data, which is not available in China. You'd have to look at or citation data to academic journals, et cetera, commercialization data, et cetera, to try to get a sense of quality. So, I hear all the talk about the competitive threat. I believe it exists, but unfortunately, we don't have much data on the quality of that competitive threat.
Well, thank you. Jonathan, just to pick up on China and then thinking globally, a number of competition authorities around the world have opened investigations into companies related to their IP practices. Many Asian companies, certainly the EU. Tell us more about the state of that and what you see moving forward.
So to kind of target the discussion, allow me to, I'm going to focus on the standard essential patents. And what I wanted to convey is how a theory that was not more than a theory and has never been more than a theory originated through a confluence of academic writing and thinking in the agencies. And the theory is the patent holdup theory. And the theory is that once implementers have made investments, the patent owners will then assess so-called exorbitant royalties. Why is it only a theory? It's only a theory because when it's been subjected to empirical scrutiny, it has never, ever met the test. In my own research, in looking at royalties and patent pools, I remember being surprised how low they were and was forced to conclude that the only possible policy problem might be that they're not high enough. Other researchers that have looked at royalty rates assessed by companies that theoretically could have incentives to hold up have again concluded, as was, I think, referenced in the prior panel, that they are a small portion of the total of the price charged to the end user. Despite it only being a theory, since roughly the 2000s, that patent holdup theory has driven antitrust policy around the world, including in this country, in Europe, and in Asia, has driven interpretations of the FRAND commitment as equivalent to, as I had mentioned, a quasi-forfeiture of the injunctive right, has driven judicial doctrines that have adopted methodologies that systematically put downward pressure on royalties to the point now where we have sort of an Alice in Wonderland world where instead of courts trying to mimic the royalties that would have been concluded in a hypothetical negotiation between a willing licensor and licensee, we have courts assuming that there is systematic market failure and superimposing judicially imposed prices upon market prices, right? Where all empirical evidence tells us that there is no such market failure. And so I would hope that the regulators around the world do what the antitrust DOJ did, which is that they took a sober look at the evidence. And antitrust in this country has historically, since at least the Chicago Revolution in the late 70s, has always been fact-based. It's always been data-based. And when you look at the data, it can only take you, if you look at it responsibly, to one conclusion, which is that the theory of patent holdup does not exist in the real world. The reasons for that are in short order. The theory used a one-off static model. It ignored repeat play incentive. It ignored iteration. It ignored the fact that most patents do not confer monopoly power. And we've seen a little bit of change in some court decisions, such as the Huawei decision over in the UK. Where there is some allowance for an injunction, but it's not much of an allowance because it requires you, when you seek an injunction, to be confident that the court would conclude that the alleged infringer had not been willing to agree to a FRAND-compliant rate, but since you don't know what a FRAND-compliant rate is up front, you're essentially back to square one where it's difficult to sue for an injunction without exposing yourself to antitrust liability. And so in the competition area, I would hope that other regulators and the other antitrust regulator in the U.S. would do what the DOJ did, which is that they took an honest look at the evidence and they drew the only possible policy conclusion that you can draw from it.
I have just one more question for my panelists, and I'm going to open it up, so make sure you're thinking of what you want to ask them. So panelists, this is your opportunity. You are the omnipotent IP czar. You have all the powers of the Supreme Court, the President, and the Congress all wrapped into one, and you get to improve the U.S. IP system. How do you do it? We're going to go down the line. I'm sorry, Adam, we're going to start with you.
That's okay. After just saying I'm not a philosopher king, so wow. So where would you start? Because the patent system and the innovation economy generally has been put under a tremendous amount of stress the past 10 to 12 years, with a tremendous amount of regulatory and judicial and legislative changes. So I would start by reinstating the same right that's shared by all property owners to a presumption of an injunctive remedy for ongoing willful infringement of your property rights. As Jonathan and many economists have explained, this is the foundation of a functioning, efficient market process. I would radically change the approach to 101, obviously along the lines that Senator Tillers has talked about and Tellis talked about, and many others, returning us back to a focus on human-made activities, human-made creations, technology, the types of innovations that have been the foundations of our innovation economy, both in the high-tech space with software and in the biopharmaceutical space with diagnostic testing and genetic discoveries. I would return back to the property-based, contract-based, private ordering foundations for licensing in the innovation economy. So I would overrule the Quanta decision and the recent Lexmark decision and allow patent owners, like all property right owners, to go out into the market and to license and to enter into all the complex arrangements, commercial transactions that all property owners are able to do in other contexts, that property owners with in new inventive technology should have the same rights. And I would ideally, I would actually eliminate the PTAB if I could have my way. It was, I recognize that it was driven by a concern about there being too many so-called bad patents and clogging the gears of the innovation economy. But what Congress created was a classic example of an agency that had no limits on it, no restrictions upon how it would function, and it turned into what a federal judge referred to as a patent death squad, with cancellation rates that range anywhere from 66% to almost 100%, depending upon which review program you're in. And this it's abused through serial petitions. It's abused by defendants who are accused of infringement, imposing more costs upon patent owners. It's devalued patents. It's made it extremely hard, especially for undercapitalized innovators, the people who drive our innovation economy, individual inventors, universities, startups, to actually get venture capital financing and to actually use their patents as the property rights to create their new companies and to become small, medium enterprises in a growing innovation economy.
Patrick?
Well, the challenge of representing an umbrella business organization is that we have members of the table take a lot of different angles on issues, which forces us to pull back to first principles. And one that, for me personally, is that a patent that's examined and granted by the United States government should carry a presumption of validity.
Mark?
Yeah, I'm going to second Adam's assessments. I have to say it's a pleasure to be with academics who have a similar perspective to my own. Sometimes a rarity. So I'm going to add a little bit to that, because I think for me, kind of being a comparativist, all these issues out of the Supreme Court, out of the PTO, out of AIA, in many cases stemmed from some fundamental misalignments within the U.S. government, misunderstandings of how technology works, or misapplication. And I think that if I was to wish for one thing, it would be we would have a little bit less ideology and more pragmatic understanding of what's going on. That goes to your point about FRAND as well, Jonathan. I think that we still think it's Fortress America here, and we're under tremendous competitive threat. So we need a level of depth in understanding our own system and engaging other countries that I think is probably not available in our current government structure. USTR is a great agency. It's understaffed, and they really don't have a lot of regional depth, nor do they have much capacity beyond doing disputes and negotiations. The ability to engage technically with other countries, provide assistance, the ability to do in-depth research is basically non-existent. The ability to promote technology, one of the few areas where we have a trade surplus in the United States, it does not exist in the Foreign Commercial Service. We once had an Office of Technology Assessment in Congress. It no longer exists. We once had a technology administration in the Commerce Department. It no longer exists. And we defunded the Office of Science and Technology Policy and China engagement. So who's there? It's like Diogenes walking around Washington. Who understands licensing? They're not here. And until you begin to understand how technology is commercialized and developed, and you put the right people on the ground, you coordinate, you deal with complex economies, and China is only one of them, where you can't just have one person who handles half the world, and today I'm China, tomorrow I'm Latin America, whatever. That's not going to work. So I would hope for more coordination and depth, and it would not be in a vacuum. I don't wish a 5-year plan on the United States, but I do think that having a global IP strategy, which is something more than the annual report of the PTO or the report of the IP czar, that really gives a sense about where we're headed, that's analytically driven, maybe draws on Patrick's good work and others, would I think also be helpful in shaping the direction the country wants to go in.
Jonathan?
Yeah, I think much has been said that I would have said, but I'll return to my point, which would be predictable by now, which is really, and it's always important to have rules that are easily administrable and short amendments. And so we're inserting and codifying a presumption that a patent that is held to be valid and infringed is entitled to a presumption of that it's entitled to an injunction, and everything then flows from there. And I just wanted to make one other point. We have been talking, as we should, about how a secure patent system stimulates innovation within the U.S. economy. But something that I've researched and I think is supported by data is that the USPTO is, in a way, also the world's patent office. A majority of the patent applicants and the grantees are foreign firms, and they're foreign inventors, and they use that patent right to access this lucrative market. This has an amazing feedback effect. And there are particular countries, and I can refer you to the paper, that have developed and leapfrogged up the development ladder in magnitudes and at speeds that have never been achieved through any foreign aid program. And they do this through the patent system, through the U.S. patent system, and it often allows them to detour around less hospitable institution conditions that they have in their own countries. And so I think a small change such as simply restoring the property rights backstop, and the ITC is a very important entity in preserving that backstop, is not only good for the U.S. economy, I think it's good for everywhere around the world, because everywhere around the world has lots of rich intellectual and human capital, and it just needs that property rights system and contract. Those two legal inputs allows wealth to be generated.
Well, our time has come to an end, but please join me in thanking our distinguished panelists.